Justice Jackson?
Yes. So I think I've heard you say repeatedly that the problem here is that Congress is giving away the power of the purse in the way that it has set this up. Is that your fundamental bottom line problem with this?
Yes.
Okay. And I guess my answer is maybe that it depends on what the power of the purse is in order for us to know whether or not it's being given away. And so I'm thinking of these two separate scenarios, and maybe, I don't know if this is helpful, but I'd like to get your reaction. So in scenario number one, we have a Constitution that gives the legislature the power of the purse, and it specifies what that authority entails. It says to exercise the power of the purse, you have to select a fixed sum of money on an annual basis and tell the recipient exactly how it must be spent. I think if that's our Constitution, then I might well agree with you that this agency structure is giving up that power because, in fact, those determinations about how much is being spent and et cetera would be given to the agency, and the Constitution tells us that the legislature has to exercise that authority. My problem is scenario two, which is the Constitution giving the legislature the power of the purse, and it defines the power of the purse as the power to decide how government departments are funded, period. That's what the Constitution says. It's got a definition section, and it says when we say power of the purse, we mean you have the ability to decide how the government is funded. If that's your constitutional provision, I think you have a harder time, if not almost an impossible time, convincing me at least that by setting this agency up this way, in which Congress has exercised that authority by deciding this is how the CFPB is going to be funded, that they have actually given up or, ceded that authority or something. In fact, they've exercised it pursuant to my Constitution. So I guess I see and I hear the government arguing that our current Constitution is more like scenario two. And so therefore, if that's true, don't you lose on this fundamental conception of you've given away your authority?
Your Honor, if that were truly the conception embodied in the Appropriations Clause, then the answer to your question is yes. But if that is truly the conception, then there really are no limits on the appropriations power. Congress
but wait, why is that a problem? If that's the conception, that's what scenario two says.
Sure, Your Honor.
That the founders said we are trying to give to the legislature the authority to make the determination of how the government is funded, period.
And that's my point, Your Honor. If your conception is that Congress can say to the President, Mr. President, you spend what you think is reasonably appropriate, full stop, period. If you think that's what it means, then I lose.
No, but what I'm asking you is help me to understand why that's not what it means. That's your burden, right? That's what the words seem to say. There's nothing in this Constitution that's like scenario one, like the Army Clause, where Congress, where the framers have specifically restricted the exercise of authority that they're giving to Congress. So what I need to find out from you is why we are not in scenario two, given the language of this, the history of the way in which the Appropriations Clause has been handled. Why isn't this just up to Congress? And if they decide they want to set it up in this way without limit, so be it.
Because, Your Honor, I think that would be completely inconsistent with the entire purpose of separating the sword and purse, which Hamilton said, if you were to combine the two, would furnish one body with all the means of tyranny, which Madison said was the most complete and effectual weapon.
But can I ask you, why is that necessarily the case? Congress could, as Justice Kavanaugh keeps saying, take it back. Congress is getting reports in this situation about what's happening. So if Congress says for the foreseeable future, what we would like to have happen is for this agency to get this amount of money and spend it on these general purposes, period. Why is that, risking the kind of tyranny that you suddenly seem to think is the issue here?
Because what you're allowing Congress to do is, I understand your question is to say to the President, Mr. President, it's no longer our determination, it's your determination. Whatever you want, whatever you think is reasonable, that is fine with us. I don't think anybody, even my friend on the other side,
So you're
is
saying a
defending
provision
that
of the
position.
Constitution is unconstitutional? Because in my hypothetical, the framers have said that in the Constitution.
Well, Your Honor,
Congress, you can set this up however you want to include allowing an agency to make this determination. So that's unconstitutional
no,
in your
Your
view.
Honor, because I have conceded that if the Appropriations Clause actually means what you're suggesting it means, I'm wrong.
Okay.
I'm simply saying that it cannot possibly be what the Appropriations Clause means, because if it were, then the game is really over. One Congress can simply say to one president in one foul swoop, Mr. President, it's up to you. Spend whatever you want. And what Madison thought was so dangerous, what Hamilton thought was so dangerous, would actually be precisely what the Constitution allows.
But of course, that's not what's happening in this case, right? I mean, I think that's the solicitor's argument is maybe if we had anything close to that, the court would consider whether or not tyranny is afoot. But for this particular scenario, there are the kinds of checks that you would expect to see in terms of Congress's exercise of its power.
2 points, Your Honor. One, structures don't crumble in a day. They crumble over time, and this would be the first very substantial step in the crumbling of that structure. Secondly, if you adopt the theory you're suggesting, then it's not really the second step for the crumbling of the structures. You simply announced, you simply announced that the structures do not stand. Here, the fundamental issue is that Congress has to make a determination as to what the government should be spending. It cannot simply say, we're going to let the president do that, because if you transfer
One
that
final
to
question, Mr. Francisco. So I'm a little worried, I think, about the separation of powers problem that may occur if the judiciary gets involved with telling Congress when and under what circumstances it can exercise its own prerogatives concerning funding. How do we avoid the slippery slope of today you say the issues are duration and source and whatever, the next agency, someone's going to come up with a few more. How do we avoid the judiciary becoming suddenly a super legislator just telling, the Congress agency by agency, whether it's a thumbs up or thumbs down from our perspective about these things? I mean, where are these limits in the law that prevents us from overstepping our authority?
Sure, Your Honor, and the judiciary has always played a vital role in policing the separation of powers, because the whole point is not to protect Congress from the president or president from the Congress. It's to protect the liberty of the people.
Right, but where are the limits that we have in order to do that? We've got to police relative to some set of rules, and where are those coming from?
And that's exactly what we've been talking about the whole time. Under the Appropriations Clause, Congress has to make the determination as to what the government should be spending. Cannot transfer that core legislative power to the executive branch. And the problem here is when you allow that transfer for a very, very long period of time, subject to a limit so high you're almost never going to hit it, you've essentially created a blueprint for the total collapse of sword and purse, the very thing that the framers thought was necessary to protect liberty in a free society.
Thank you, counsel.